Okay, I think we can get started. Good afternoon, good morning, everyone. Thanks for joining on this beautiful Sunday in Las Vegas. I hope it's the same everywhere. This is the first of our webinar series conducted by the mentorship board of the St. Anthony's College Old Boys Association in USA to start with this immigration topic. Let me hand over to the chairman of the mentorship board, Dr. Lakshman Denipitia, to start the proceedings. Lakshman?
Oh, thanks, Aruna. Can everybody hear me?
Good, yes.
Okay,
Yes.
all right, good. We have mentorship services for SACKOBA-USA members and St. Anthony's College Pentecostal alumni who are planning to immigrate to the USA. And some of the things that we have are professional networking, career development, educational opportunities, settling in the USA, resettling in a different state, personal development. I am happy to welcome all the SACKOBA-USA alumni and guests who are participating today to this webinar. We are very happy to have a renowned speaker, immigration attorney from Pasadena, California, Chanaka Ramanayaka.
Much obliged.
This will be an interactive session titled Know Your Immigration Rights. At this point, I would like to hand over to our President, Aruna Abekon, to introduce our speaker.
Thanks, Lakshman. Once again, thanks everyone for joining. So it is my absolute privilege to introduce Mr. Chanaka Ramanayaka, who is a licensed attorney in the state of California, who has extensive experience in immigration law. He has helped thousands of clients representing them before the U.S. Citizenship and Immigration Services in adjustment of status applications, naturalization applications, and removal of conditions applications. He has also helped clients from around the world in providing consular processing services. Additionally, Chanaka provides services that include asylum applications, business visas, employment visas, student and tourist visas. He holds a LLB honors from University of Middlesex in the UK, a diploma in forensic medicine and science for lawyers from the University of Colombo Medical College, and LLM from California Western School of Law in San Diego. He is a member of the California State Bar Association, Los Angeles County Bar Association, American Immigration Lawyers Association, and the Bar Association of Sri Lanka. He is the principal attorney at the law offices of Chanaka and Ramanayaka in Pasadena, California, and the managing attorney for immigration and refugee resettlement services at Catholic Charities of Los Angeles. So without any further ado, Chanaka, over to you.
So thank you, Aruna. Thank you all for joining us today. I know it's a Sunday weekend, but I think you all have, taken time away from your personal, time to join, educate yourself during this tumultuous, administration, right? Tumultuous times in USA when it comes to immigration. So today I'm planning to educate y'all on a few matters concerning deportations, right? Arrests by ICE, issues faced by undocumented aliens, right? So non-citizens, those who do not have visas, who have fallen out of status when it comes to visas, right? And also people who have status, but maybe to gain some form of, knowledge, right? So to be conversant with the prevailing situation in USA when it comes to immigration law. Immigration law has been a litigious topic, quite recently, ever since the new administration came. And also we experienced the same during the Trump's first administration too, right? As per the updates that I've received from American Immigration Lawyers Association and my colleagues, this is just the beginning. So there could be many other changes, affecting various other immigration areas, not just undocumented people, right? H-1Bs, family immigration. When it comes to deportation, they have drastically changed the policies. So without further explanation, a general explanation of the situation, we'll go into dive into the specific aspects of immigration changes that we are experiencing nowadays, right? So this is just my law firm, although based in Pasadena, we provide services across USA and around the globe. I could provide the slides, to Aruna to be distributed just in case for those wanting to reach out to us, wanting us if they want to reach out to us for our services. We cover a plethora of immigration services, and also when it comes to California, not just immigration, we provide services, in terms of family law, personal injury, and various other areas of law. So today's topic, it will be know your rights, what steps to take if you encounter ICE. ICE is, as you all know, is the enforcement arm of Department of Homeland Security. All the arrest detention are conducted by ICE, right? Immigration and Customs Enforcement, and the family preparedness plan. If in case, if you are, if a certain person has the unfortunate, encounter with ICE, what he or she should do proactively to prepare well in advance, right? Community protection points, we'll just briefly go through these. This is an overview of what should be done. Remain silent, do not open the door, speak with an attorney, which is basically common practice when you fear that you might get detained by ICE, right? Do not sign anything, show red card, do not show false documents, stay calm, do not run because it's an obstruction of their duties. Make a family plan. I briefly touched on it just now, and it's your decision, meaning it's your discretion to actually, the degree as to which you should take my advice, and also, the manner in which you should proceed forward. So the inauguration of President Donald J. Trump, right? So just like his, policies that he promulgated during his campaigning, and also the policies that he wanted to enforce during his first term, we are seeing a lot of, follow-up what he has been doing in his first term, and also, trying to execute his political promises during his political campaigning for the presidential election. For example, non-citizens lacking immigration status, even though they have community ties, meaning if you don't have visas, if you are out of status, if you fall out of status, even if you have a US citizen or green card holder wife, spouse, right? Wife or husband, even if you have children, there is a huge chance, as per the current policies, that you may be placed in deportation. So that's the policy change that I was talking about. So Aruna, we'll have a quick question and answer session soon after.
That is
the
correct,
presentation, right?
Chanaka. Yes, you can go ahead, and for everyone, if you have any questions as Chanaka goes through these topics, please type them in the chat section. We will bring them up at the end.
Yeah. So who would be at risk of deportation, right? So if you're on status, if you got a visa, there's nothing to worry. Why? As per the immigration rules, a person would be deportable if in case a person falls out of status, meaning a person who's undocumented, or while on status, meaning a person who has a visa, that person would violate the terms and conditions, right? So when that person violates the terms and conditions, that person would also be considered as out of status. Mainly when it comes to Sri Lankans, in my experience, I have clients who are Sri Lankans across USA, Texas, California, New York, Las Vegas. We have people who are students. We have people who have come on a C1D, right? Visas, those who have come to join cruises, come on cruises, and then, jump ship. No worries. And then those who have come on B1, B2, right? On business and tourist visas and have decided to stay. And also we've got people who have come on green cards, right? But unfortunately, due to family issues, divorce, now their green cards are about to expire and they don't know what needs to be done. I have clients who have green card holders, but they have had the unfortunate situation of being convicted of certain crimes, right? So that would expose them for deportability. So there's a huge plethora of issues that an immigrant would face. These are certain obstacles that we have to avoid with the proper guidance, right? That could be sort of like, the negative consequences can be, reduced, could be avoided, given the, proper guidance and advice, I believe. So we'll go from the points and thereafter I'll explain what each point is. Non-citizens with prior removal orders or without current status are at heightened risk for immigration enforcement and should be counseled on how to answer, right? So what does this mean? If when it comes to Sri Lankan clients, some people, some clients, they file for asylum applications, right? And once the USCIS denies the asylum application, invariably, if that person is not on status, he or she would be placed in deportation, meaning the person would be referred to an immigration judge, where the person would then again seek asylum in front of the courts. So if the person is not properly represented, that could lead to a deportation order by the immigration judge. And those with the deportation orders are at heightened risk. So the ICE would they would have a list of people who have been issued with these deportation orders. They know where they are unless these people change their addresses, residences, and they may come in search of them, right? So they're at heightened risk because they have the deportation order and they're already deportable. So that's why and there are quite a lot of Sri Lankans, with this facing this particular issue. And as per the latest statistics, I believe 3,000 odd Sri Lankans have been deported. There are credible reports of officers coercing individuals to accept voluntary return by threatening long-term detention. So beware of this tactic. What is voluntary return? Voluntary return is basically the person if that person is detained by ICE, Immigration and Customs Enforcement, again, the enforcement arm, right? They are like the immigration police. So as you say, that person, without being referred to an immigration judge, would be deported if that person signs that document. So it's a voluntary return, meaning that you're volunteering to go back to your country without arguing your case, without litigating your case before an immigration judge. And the ICE, basically, it's not a new tactic. It has been here, but it has been in practice for such a long time. They would threaten the person with long-term detention if that person does not sign the document. Now, once that person signs that document, that person would be at the mercy of ICE, meaning there's no way that person could advocate asylum or any other form of relief that could be available to the individual. So that's why we see people now being deported to Panama, right? Awaiting, deportation to their respective countries, right? Being detained without seeing an immigration judge. It is advised that those arrested refuse signatures on documents that they cannot read and understand. This is actually a continuation of my second point. ICE is known to, use illegal tactics to come to your house, right? Come to your residence, workplace, to stop you out in the public and then coerce you to sign those documents so that they could, with ease, deport that person without fighting it out in court. Specific suggestions regarding expedited removal. Let me see. So what's an expedited removal? Expedited removal is, as the name suggests, no immigration judge, no litigation. They would be directly deported, and those deported would not be able to come back to USA for 5 years. This is quite unfortunate, even if that person has, family members who are US citizens. That person could have, like, could have a fiance who's a US citizen, right? Now they're about to get married, but face the unfortunate situation of like being detained by ICE and then expeditedly removed. That person would be barred for 5 years, meaning no family petition could ever be processed, and then that person would ever be able to come back for a period of 5 years. As the point suggests, once an immigration officer determines that non-citizen is subject to expedited removal (ER), they are ordered removed. It's a process which is out of court, out of the judicial review. They would just be deported. Just like I basically take the example from Sri Lankans, from Sri Lanka, because that's where we are from, and then we know about the statistics, right? We know about the immigration issues faced by our fellow Sri Lankans across USA. So my hunch is that they must have been subjected to this ER, expedited removal. So unlike other removal orders, just like I said, ER order carries 5-year bar to re-entry, and there is a way around it. So with proper guidance, like I said, if the person is detained and the person is exposed to this expedited removal, that person could claim asylum. Let's just say that he or she faces like a persecution, some form of persecution based on political opinion, or maybe from his own whole family, right? Could be based on religious grounds, or for some form of other applicable asylum ground. Now, if that person faces such a threat of persecution, that ground should be raised at that time. So what happens when a person says, "Hey, I fear going back to Sri Lanka because I have this particular threat in Sri Lanka." That person would not be deported, would not be subjected to expedited removal. That's one of the best strategies to be utilized. And actually, a lot of Sri Lankans in USA, as per the inquiries, thousands of inquiries I have been getting, I don't think that they are aware of the strategies to avoid deportation. So once that person says, I'm afraid of returning home because there's this pending persecution or foreseeable persecution that could be subjected to, that he or she could be subjected to if returned to home, then the officers cannot deport you to to your home country. So what follows then, right? So if you say, I'm afraid of going back, that person would be then referred to a credible fear interview, meaning whether that fear is credible. Can they believe that, right? So that is the foundational, that's the basic assessment for asylum, whether what he or she is saying is credible. Can we believe that? So if it is, if they find it, if they find the fear is credible, then asylum would be granted. If not, then basically he or she could argue it before an immigration judge. So that's the best way to avoid expedited removal. That's the best way to avoid where a person is detained by ICE and then and about to be expeditedly removed. I'm of course not referring to made up persecution, right? So if there is a possibility that the person could be harmed back in Sri Lanka, those issues must be raised with ICE as soon as possible. Current policy of ER, right? So now the expedited policy applies to a specific number of non-citizens. So non-citizens and inadmissible removal due to misrepresentation or lack of valid visa or entry documents, meaning you lie at the border, you have false documents at the border. Border meaning it could be land and it could be at the airport. A person could be coming with a tourist visa, and if they suspect that this person might end up, residing in USA, or if the person has some ulterior motive of working in USA, the visa could be revoked and subjected to expedited removal. Non-citizens are encountered at a port of entry or anywhere in USA, again, at the airport, at the land border encounters, they could be expedited removed, meaning no immigration judge, no recourse, no appeal, right? They could be subjected to expedited removal, and they would be at the mercy of CBP officers. Non-citizens unable to demonstrate continuous physical presence for 2 years. Now, if you are basically right now, the expedited removal policy applies to when it comes to third point, they would expeditedly remove people who do not have status and who have not been in USA for at least 2-year periods. Now, will the ICE really follow this particular policy? It's doubtful. You do have utmost confidence in ICE that they would, follow this policy verbatim. I do not place my utmost confidence in that. So we always have to, just be prepared for the worst case scenario, meaning, raise those credible fear interviews of going back home, right? So as per the policy guidance given by American Immigration Lawyers Association and also the Department of Homeland Security, you should have evidence of physically residing in USA for at least 2 years to avoid expedited removal, right? And then non-citizens who has not been admitted or paroled. This one rarely applied to Sri Lankans, although I've come across Sri Lankans who've come, crossed illegally to USA, illegally meaning without a visa, through Canada, mostly from Canada. And I've not come across Sri Lankans who've crossed the border without a visa from the southern border or from Texas. So I have come across people who have crossed without a visa from the Canadian border. So this applies to them who have come to USA without a visa. So ER again, as per the policy, it does not apply to people who are already in deportation, right? If you are in deportation, if you are before an immigration judge, now the immigration judge has jurisdiction. The ICE cannot do anything. Now, there is a policy where they say the ICE could advocate to get the deportation proceedings dismissed and then place them under expedited removal and then deport them right away. How successful would that be is doubtful, right? So because it's up to the discretion of the immigration judge to review the position of ICE and see whether the deportation proceeding should be dismissed and then whether that person should be placed in expedited removal. I highly doubt that would be the case, because when you are before an immigration judge, the judge is supposed to litigate the case, adjudicate the case as per the rules of immigration law. And every person has the right to appeal an erroneous or any decision by an immigration judge. So I don't think that would be the case for when it comes to people who are already in deportation proceedings. Unaccompanied minors, this rarely applies to Sri Lankans. Those are minors who have been abandoned by their parents, who have been neglected by one or more of their parents. There's a whole nother immigration procedure avenue where unaccompanied minors can become green card holders. So that would rarely apply to Sri Lankans. Applicants for admission under the visa waiver program. So, these are people coming from under the visa waiver program, coming from UK, European countries where they don't have to apply for the visa. So under the visa waiver program, they are issued a document called ESTA, where these people can tour USA for a period of 90 days, but they must go back. So those are not, those coming under the visa waiver program would not be subjected to expedited removal. And then US citizens, green card holders, refugees, asylees who have not had their status terminated. If you are a green card holder, if you are a US citizen, or if you've been successfully, litigated your asylum case and got the asylum status by USCIS, immigration judge, um, you would not be deported, right? So that's basically quite common, and then everyone knows about that. Non-citizens with approved petitions or U visas. I have a few Sri Lankans who have pending U visa applications, but the U visa has to be approved. U visa is a visa where the USCIS has exclusive jurisdiction. It's granted for people who have been victims of crimes such as domestic violence, felonious assaults, kidnapping, wrongful restraint, right? And they have helped the police to investigate. So if you've been a victim of a crime and you have helped the police, there is a pathway to the green card, to become a lawful permanent resident. The U visa, there's a huge plethora of other visas available. So depending on case by case, status, case by case analysis. I'd be happy to guide whoever who would reach out to me, depending on the situation, what needs to be done, so that the American dream could be achieved, right? Non-citizens that were permitted to withdraw their application for admission. So this is applicable to those people who are at the border or at the airport. So if the CBP suspects there's something going on. For example, just like I mentioned, B1, B2 visa, if a person is coming on a B1, B2, that person should not be working in USA, should not be, for example, giving birth to a child, coming to USA to give birth to a child, right? Right. So the child become a US citizen, should not be coming to USA to reside, to work. However, if there's evidence to the country, if the CBP suspects that this is not the motive of the person coming on this particular visa, that they could be expedited removed. So one of the ways to avoid this expedited removal, why? If you're expedited removed, you're barred for 5 years, and also it's a negative point. So once you're expedited removed, the chances of you securing another US visa are very slim. I've never come across a person except for where they migrate to USA on family immigration. I've never come across a person who have been expedited removed and who they thereafter got a successful visa approved, like a tourist visa or student visa approved. They've never been successful, unfortunately. So if you withdraw your application at the border or at the airport, then you could certainly avoid expedited removal. Individuals who are admitted or paroled, again, even though you come with a visa, if you've overstayed your visa, if you're not on status, and you've lived in USA for less than 2 years, you could be expeditedly removed. How to prepare for expedited removal. Collect evidence of physically residing in USA for 2 years, like I said before. Carry proof of pending applications or petitions. If you have a pending asylum application, family immigration, right? You could be married to a US citizen, right? Green card holder, or you could have a pending U visa, VAWA application, right? So carry proof of those applications so that you maybe have a chance. But I will walk through all the constitutional rights available to all of us to really challenge illegal activities of ICE. That way, you could possibly avoid being detained by ICE and possibly avoid being deported. Ensure you know your rights when speaking with ICE. Yes, so all of us have rights, even if you have status or not, even if you don't, if you are a green card holder or not, even if you are a US citizen or not. Those are constitutional rights, given rights enshrined in the Constitution of USA. So we will go through those rights in a bit. Every person within USA has certain basic rights, regardless of immigration status. So what rights do we have? So the Fifth Amendment, right? So Fifth Amendment is pretty famous among everyone. I recently, just to digress, recently watched the Netflix documentary on O.J. Simpson, where the police officers then pleaded the Fifth Amendment. So what does Fifth Amendment means? Fifth Amendment means whatever you say cannot be used against you. So you have the right to remain silent. This amendment can be raised by all of us, right? By all Sri Lankans to remain silent. They do not have to be coerced into answering anything by ICE. So under the Fifth Amendment, you have the right to remain silent, right? So, you must have seen or heard or even experienced, the police, arrest, they always give that Miranda rights, right? They have to give the Miranda rights to the suspect that they're arresting. You have the right to remain silent, right? So anything you say or do will be used against you in a court of law. So the Fifth Amendment is that right. A person does not have to answer questions that ICE or other law enforcement officers ask, because people cannot be required to provide self-incriminating testimony. So what are the rights under Fifth Amendment? Right to remain silent and due process of law. Due process of law meaning you have the right to litigate your case in a court of law which has proper jurisdiction. You have the right to refuse to sign documents. If they give you a document, if ICE gives you a document, do not sign it. You can plead the Fifth. They cannot do anything about it. Will you be detained? They have the right to illegally detain, right? They don't. Let me rephrase that. They could illegally detain you, even if they don't have the right? But that could be then argued in a court of law, right? But you certainly have the right to refuse to sign documents. You don't have to sign anything. Can refuse to give documents if they ask for papers. From you're driving. One day you're driving down the road or walking down the road or working, and ICE, you encounter ICE, and if they ask for proof of your status in USA, you can certainly refuse to give documents, and you can plead the Fifth Amendment. So that's a very powerful constitutional right you can utilize to arm yourself so that you would not be harassed or placed in deportation or could be to avoid an unlawful, illegal search and inspection. So the Fourth Amendment basically protects you from unlawful searches and seizures. So without a warrant, they can't do anything. So we'll go through a bit touch base on this in detail, so that you know what the Fourth Amendment covers. So ICE or police in general cannot enter a person's home or search a person's belongings without permission from the person or a warrant signed by judge or magistrate, right? So I've seen videos shared by other on social media where ICE basically ask the person to open the door. Once the person opens the door, they would come in, they would force themselves in, because now that the person has opened the door, allowed ICE to come in. So the rights under Fourth Amendment, the right against unreasonable searches and seizures. ICE and law enforcement cannot enter a person's home or search a person's belongings without permission. To paraphrase this, what does that mean? It means that without a valid warrant issued by a court, not by ICE, not by immigration, right? By court, the ICE would not be able to search your belongings, would not be able to search your vehicle, would not be able to search your house. They cannot come inside your house, and they cannot come into your place of work and search your workplace unless you give permission. So should you give permission? No, absolutely not. You must always refuse, right? So they never have a judicial warrant. They use a warrant called ICE warrant. Actually, it has nothing to do with the judicial warrant, but they utilize that to trick, unsuspecting individuals to grant permission. So once they grant the permission, they can enter your place, they can search your place, they can search your belongings. So the Fourth Amendment, right? So the Fourth Amendment is also can be utilized to stop ICE or to protect yourself from unlawful searches and seizures, right? ICE warrant is a form issued by certain immigration officers that names the allegedly deportable non-citizen and directs various federal immigration enforcement agents to arrest that individual. So a ICE warrant and judicial warrant are completely different. They cannot utilize the ICE warrant to search a person, enter up, that person's residence, enter your workplace. So this ICE warrant is basically a directive given to ICE officers to go, basically says, hey, go to this person's residence and arrest that person. So, but the thing is, they cannot come inside, they cannot search you based on this. So there is a constitutional, so it's contrary to our constitutional rights. It's contrary to the law. This is mainly because, um, there is there is this friction, or there's always these issues between the execution of immigration laws and your constitutional rights. Then they have to be litigated in a court, right? An ICE warrant is not a real warrant. Like I said, it's not reviewed by a judge or any neutral party to determine if it is based on probable cause. Warrants are issued on probable cause. The warrant has to be issued by a judge, not these ICE warrants. So in a bit, I will share an example of an ICE warrant so you'll know what it means. Because it's not issued by a judge, an ICE warrant does not give the immigration enforcement officer the authority to demand entry into a home or private space to make the arrests, right? Like I said, ICE warrants do not generally provide a basis for local or state law enforcement officer or agency to arrest or detain anyone. So these warrants cannot be executed by local, right? Your state law enforcement. It could be the LAPD here, or right, Las Vegas Police Department. They cannot use this ICE warrant to detain you or to even come and search you. So I have shared an example of an ICE warrant. Aruna can share these slides with the fellow members of
Sure
your
thing.
association so that better understand what these are, what these constitutional rights are, and then have a look at this ICE warrant. This is what it usually looks like. And if you see something like this, do not give permission to come to your workplace, not your residence, and you don't have to allow them to search your belongings. ICE can only deport if they have proof that you're not a citizen, right? Or a green card holder, or if you don't have status, right? Do not give them proof by answering questions or providing documents. You have the absolute right not to refuse to answer questions. You have the absolute right to, like I said before, under those Fourth and Fifth Amendments of the Constitution, you have the absolute right to refuse to give documents. Do not say where you are from, where you were born, or nationality. If they ask you where you're from, where you're born, you don't have to answer. You can plead the fifth, right? I have actually, indicated a few examples, how to attack questioning by ICE. So the Fifth Amendment, rights before ICE. If they ever ask you where you're from, I assert my right to remain silent. Where were you born? I assert my right to remain silent. What is your nationality? I assert my right to remain silent. You all may have solid status in USA, citizens, green card holder, but I mean, I think the information could be useful to share among your fellow members of your association, friends, and family, right? Avoid arrest entirely. That's our goal, if it's possible. Of course, ICE could illegally arrest you, right? And then if they really illegally arrest you, then what is our plan B? Should be then to assert persecution, right? If you have a valid case, or you have that option to raise persecution in your home country. So what can you tell ICE, right? You can tell if you fear returning to your home country. Like I said before, you have to respond honestly to questions. Don't say that you are a US citizen. So that's a false claim to citizenship. That's like a permanent bar to any immigration relief that you could have in the future. Do not say anything to anyone about your status except your attorney, right? You can say, hey, I wish to speak to my attorney. I don't wish to speak to you. And then you can assert your right to remain silent. What you shouldn't do, what should not be done. would be to resist arrest. So if you run, that would be obstruction of justice, right? So obstruction of their duty, execution of their duties, that could raise other charges against you, right? Not certainly you all, but a person who doesn't have status. Sign anything or make any decision without a lawyer. You don't have to do it. So the person facing ICE should not be coerced or forced into making any decision without a lawyer, right? Answer question about immigration status or country of origin when ICE comes to question you at the detention center. For example, if you are detained and then thereafter, if a person is exposed or like subjected to questioning, you can remain silent. You don't have to answer. You can give your date of birth, right, and name and address, but you don't have to do anything else apart from that. What to carry? Red cards. Red cards are basically cards produced by certain institutions, advocacy groups in USA that have the constitutional rights written on them. So you can simply show those rights to the ICE officers or immigration enforcement officers or state officials if they state law enforcement officers if they come knocking on your door, or if they unlawfully inquire into your immigration status. State and local forms of identification. You should carry your driver's license, even a library card if you don't have one, right? And then driver's license is a must, right? The constitutional rights do not really protect, enforcement of traffic violations, right? And then copies of immigration documents showing lawful status. Hey, if you are on lawful status, if you got your visa, then do carry that. But you shouldn't carry originals. Do carry a copy. We don't want to lose our, visas and then thereafter face these other issues, right? Because getting hold of another copy could be cumbersome. Contacts, legal service provider, emergency contacts. You can have contacts of family members, attorneys at your disposal just in case. Do not carry your passport. Don't carry your consular identification card or anything like that. That would sort of establish that you are a citizen of another country, or to show that you are you don't have any status in USA. What if ICE comes to my home? Again, like I said before, you have the right under the Fifth Amendment, right to remain silent. Do not sign anything. You can remain calm. Don't panic. Nothing. Do not give ICE permission to enter your home if they come knocking. You can let your friends, family members, members of your association know they have the absolute right to refuse to enter their home and search their belongings. Do not open the door. Never open the door, because once you open the door, that could imply that, hey, you have given the permission to ICE to thereafter enter your home and search your belongings. So those are once these, if you do not assert these rights, there's a huge chance that that person could be placed in detention and thereafter deportation. So we want to avoid detention. We want to avoid deportation at all costs. So better utilize these tactics, which are rightfully yours under the Constitution. Slide your red card under the door. Again, the red card is a card that basically has all the rights written. Ask for a warrant signed by a judge. They are going to show you that ICE warrant. That's actually not a real warrant, and they are going to I've personally seen videos where they use that warrant to trick people, like coerce people into signing documents, opening their doors, so that they could even certainly it's illegal, but to question them, detain them. Thereafter, once you're detained, now you're facing deportation, right? Risk of deportation. State clearly that you are asserting your Fifth Amendment right to remain silent, and do remain silent, right? So once you assert the right, you don't have to thereafter talk to anybody, right? So then thereafter, what needs to be done is to call a lawyer. What if I encounter ICE in the community, right? Out in the public spaces are not private spaces, right? They can come and question you. They can come and stop you, right? So walking, driving, and other public spaces. Again, these rights do apply to public spaces as well as your private residence or your workplace, right? assert your right to remain silent, do not sign anything, remain calm, right? So why remain calm? It's one of the it's basically not to arouse any suspicion, I guess. Do not consent to a search of your person or your property. Person, property meaning you should not give consent to ICE to search your person, your body, or your property, your vehicle, your belongings that you may be carrying. You could be carrying a bag or something like that. So don't give permission, right? You have the constitutional right to refuse. Excuse me. Refuse that. Do this even if you have status. Even if you have status, you can assert your rights, or you can, if you have status, you can show your status. But if you want, like I said at the beginning, it's up to you, like your discretion. If driving, the driver should show the driver's license. So these rights don't cover those, right? You should always abide by the, vehicle traffic rules and have the driver's license present with you at all times if you're driving. Do ask if you're free to go, right? So if you refuse to answer, raise the constitutional rights, and then ask, hey, officer, am I free to go, right? And then do not speed away. If they try to stop you, do abide by their instructions. Again, if you speed away, if you run, right, if you obstruct the execution of their duties, right, their powers, then they could press charges against that particular person. False documents is a big no-no. Why? Because there are bars to immigration called misrepresentation, document fraud, and false claim to citizenship. Do not use those false documents because they could take those documents into custody, and then they could utilize those documents to attack you in court if you are placed in deportation, right? And you're a business owner, so you could be owning a shop, or like you could be a manager at your workplace, right? You could be some other form of entrepreneur. What rights do you have, right? So what can you do? Have a process in place, right? So you can let your staff know what their rights are. For example, train your staff not to talk to ICE. They can say you are not allowed to enter, and you must speak with my employer, right? So, and like I said, under the Fifth Amendment, under the Fourth Amendment, they cannot come without a valid warrant. They cannot search you without a valid warrant. So the entrepreneurs, managers, employers, I think it's a huge must to educate their staff. I have a lot of clients in Las Vegas too, and I see that, I hear various stories where they have put up checkpoints in Las Vegas to check they check people for their status by ICE. So I know this is a huge reality. You and I have not faced this, and you and I may not have the same frustrations, issues, concerns that like millions of people may be facing, but I think it's a reality. We have to wake up to that, I think, unfortunately. Public areas, anyone may enter a public area, including ICE, right? Being in the public area does not give ICE the authority to stop, question, or arrest just anyone. So like I said, they don't have the authority to stop anyone, question and arrest. There has to be probable cause. To search a person, they must have a valid warrant. If they are ask questions from you, you have the Fifth Amendment to remain silent, right? Business owner and the employees can ask ICE to leave. Yeah, do ask them to leave and that they are not authorized to enter, right? Private spaces remain private even for ICE, right? That's your space, that's your residence, that's your employment. Without a warrant, they cannot enter, right? So it's your domain. You cannot, without authority, proper judicial authority, they cannot enter and then execute their duties in any way, in any manner that they deem fit. ICE cannot walk into these areas without permission or a judicial warrant. Do not give them permission. Ask for an inspector warrant or call your attorney if you come across a warrant. If a person would come across a warrant, like I said before, it's always best to keep the contact number or the detail of an attorney, right? Details of a immigration law attorney, just in case if that person would come across an ICE officer, or if the ICE would come to your workplace and start questioning you. If ICE enters without permission, do not interfere but take notes. Again, you cannot interfere with their duties. You can only raise constitutional rights, right? You can only raise those points that I've discussed up to now. But you don't have the right. The person does not have the right to interfere with their duties, right? Um, are you an employee? So a person could be an employee working at a shop or some other, workplace. So you have the right to remain silent. Again, you don't have to sign anything. You don't have to consent to search your person, meaning your body or property, your belongings. If they ask you to get in a line, uh, do not get in the line, because then they could start interrogating you, right? Those are tactics that the ICE would use, so that it could be implicit. You'd give the implicit permission for them to question you, right? So ask to speak to an attorney, right? So you always have that right. Speak to an attorney. If ICE comes to jail, again, you can raise those, constitutional rights, decline the interview, proceed with the interview but with an attorney, or proceed with the interview with or without an attorney, right? But if you are detained, always decline the interview, always remain silent, always ask for an attorney, and don't give any information whatsoever to ICE until the attorney reaches you or you get in touch with the attorney. Courthouse arrest, this is very unfortunate. I have now, there was a policy in place during the first administration of Trump, where they did not raid schools, churches, right? Places of, sensitive places. But now I hear that, there are no bars to, where they would search people, where they would arrest people. Even courthouses during his first administration, and I'm hearing the same right now. These people were arrested at their court, like while going to court for a case, or while going to USCIS for their appointment, for their interview. So it's always, best to speak to the attorney and have the attorney ready just in case if the person is detained. Family preparedness plan. I know that we are running, out of time. So just to sort of sum up what the family preparedness plan is, it's quite, practical. Just in case those who do not have status can have someone, just ready to take care of their children just in case, right? In California, there are, caregivers authorization affidavit. It's a form of affidavit which is given to the person so that the person, that's only available in California, but in Las Vegas and Nevada and other states, I'm sure they have their own form of affidavit where the caregiver, right, not the parent, is given the authority to make certain decisions when it comes to schooling, medical issues, right? Another form would be the guardianship. It's a more formal way of conveying authority through court, probate court, right? Another one would be power of attorney. So all these, strategies of family preparedness would be only applicable to people who do not have status, and people who do not have status and have children who are of ages, where they need constant care and attention, just to have a family preparedness plan in case that person is arrested. So these are all, points of family preparedness, what should be done. In this, I'm just going to out of these, I'm just going to touch few points. Family members can use the ICE detainee locator. There's a locator. If a person is detained by ICE, how to search, right? How to locate that person. So there is a link where the person can go to, the family members can go to locate that person using the alien number, right? Children born in USA get their US passports, right? Because, if a family member is deported, right? So the children should be able to sort of go with the family member, go with their parents. Certainly, if US born children, they have a way of coming back to USA. But if that person is then expeditedly removed, that 5-year bar is also applicable, right? So we will go to Aruna, we will go to the Q&A session. I know that you said keep 45 minutes for the presentation and thereafter the remainder for Q&A. I've gone a bit beyond that.
That's fine,
So
Chanaka.
we'll now
Yeah,
keep some time for the Q&A. Thank you.
absolutely. Thank you for that enlightening enlightening on some of the key areas.
Yeah,
And
much
as I
obliged. No
mentioned,
worries.
there is a big membership among our old boys who are in H1s, F1s, and all that, right? So, and also some of the citizens who are sponsoring their kit and kin. So, let
Yeah,
me share my screen and go through those questions that we have received one by one.
sure, sure.
Okay. Can you see my screen, Chanaka?
Yeah, yeah.
Okay, so the first question is, what are the options for job seekers who has STEM OPT but not having experience to do so after their 1 year OPT ends?
So what are the options for job seekers who has STEM OPT but not having experience to do after one, right? So basically, the main reason why you would go into STEM OPT is to secure employment, right? To secure a sponsor, an employer willing to sponsor you for your H-1B. Of course, it's a lottery. So during this time, if you're unable to secure a sponsor who's willing to sponsor, even though if it's, like I said, it's a lottery, right? But I've had clients who've been Sri Lankan clients who've been lucky to win that lottery, and now they've got their H-1Bs and now proceeding with their, green card I-140 applications. So the next option would be to then continue with your education. That's the best option. That's the best strategy that you can take. Go for another F1, right? And then proceed with your master's or other form of studies, so that you would be on status and you would have a chance of either exploring employment immigration or family immigration, right? Depending on your marital status. So those are the strategies available. You know,
Okay, thank you. So
no
I'm
worries.
inviting everyone. I think I'm reading out some of the questions that you
Yeah,
have
yeah,
previously sent
yeah,
or sent now. So if you have a follow-up question, so please speak up. And until then, I'll advance to the
yeah.
next question.
F4
I think.
processing time. Yeah, it has been 5 years for F4 application. Now it's at NVC. At this point, I wait as I'm not having access to PACE here. Right. Basically, F4 siblings of US citizens, it's a common question that I get, not just from Sri Lanka, from around the globe. I have clients in Pakistan, Bangladesh. Uh, I actually have a client who has been waiting for many years now. His siblings in Bangladesh, they've gotten their interviews. So F4 has a very long waiting time. I believe it's about like 12 years. Uh, so even if the I-130 is the initial petition, even if it is approved, you got to wait until the visa is available to go to the next stage, right? The SIAC stage, right? Now, when it comes to the SIAC stage, the question is at this point, do I wait as I'm not having access to pay SIAC? That means that it has been 5 years, right? So you have to wait a bit more, unfortunately, until the visa is available. NVC, National Visa Center, their visa bulletin is updated every month. And that's why we cannot sort of give a absolute prediction as to the waiting time because it's updated. And we are actually at the mercy of the National Visa Center when it comes to processing times. So you got to wait a bit more and you have to follow the visa bulletin. But once you see that the visa is current, you have to actually reach out to the NVC. If you don't have that NVC notice to proceed to the next, second stage. So if you have any doubts, do reach out to me. I'll be more than happy to help you out.
Thanks, Janaka. Next one, delays in H1.
Yeah, so delays in H1B, processing employment-based visas. Again, we have to look at the processing time. If it is beyond the processing time, you have another strategy that you can utilize. We can reach out to the USCIS Ombudsman, Institute. Ombudsman in Sri Lanka, the Sri Lankan term is Duganarara, right? Ombudsman, right? In Sri Lanka also we have this ombudsman. So ombudsman is a basically independent body where the USCIS has taken more time than indicated or published to process a certain application. Then we can reach out to the ombudsman. The plan B would be to, plan C would be to then reach out to your Congress for a congressman or senator for a congressional inquiries. I personally have successfully done those congressional inquiries where we reach out to senators, congressmen, or women to inquire into the processing times and delays because they have the absolute right to look into the federal agencies as to their anomalies and erroneous decisions and whatnot. I think that's the best way to go because delays, renewals, those are basically, unless they are litigated at the court and the court makes a decision, we are basically at the mercy of USCIS.
Got it. In terms of renewals, Chanaka, I mean, if the renewal is delayed, but you're still in status, right?
Yeah, yes. Yeah.
Got it. Next question. Advice for F1 visa holders seeking sponsorship for jobs with challenges to find employment opportunities who sponsor even with STEM or PTE.
Sponsor jobs with challenges to find employment opportunities who sponsor even with so that's basically an unfortunate situation. Even Indian students, right? Not just Sri Lankans, Indian. We've got a ton of Indian students, relatively, exploring these job opportunities. They constantly inquire as to like what should be done. Like I said earlier, if you are unable to find a sponsorship, then do continue your studies so that you can be on status and then keep looking for job opportunities or family immigration, right? So, for example, if you're unmarried, based on your marital status, if you're unmarried and if you get married to a US citizen, I'm of course talking about genuine marriage. Even if you've fallen out of status, even if you work without authorization, you are eligible to get that green card, right? Because US spouses of US citizens can fall out of status, violate their non-immigrant visas, and still get their green card. So they are privileged. But if you are not willing to explore that avenue, family immigration, then you have to be on status. To be on status, you got to then continue your studies.
Got it. Next one.
Family employment based, green cards have significant delays. I've been looking at reports issued in when it comes to USCIS, Department of Homeland Security. They're cutting their budgets. The budget was was reduced during the Trump's first term too, and there are now significant layoffs when it comes to immigration judges. We need a lot of immigration judges to sort of, just adjudicate, matters in immigration court, and they are laying off judges and they're laying off USCIS. So these things, and also there was a huge, processing delay during the COVID because COVID pandemic, because all these agencies, their daily work was suspended. Their processing of, various projects, applications when it comes to USCIS were suspended, right? Now, of course, after few years down the line, these delays have eased significantly, but I think we are still facing that backlog and the challenges faced by USCIS during the COVID time and also due to the budget cuts and layoffs. So that's something. If there is a huge delay, and if the delay is beyond the published processing time, then we have to reach out to that ombudsman. We've got to reach out and advocate with the local congressman, congresswoman, or senator who has who has the particular jurisdiction, so that we can get some form of relief, right? So those are the strategies that we can utilize, or we can go for a mandamus litigation right in court, in the federal courts, where we litigate the case and then try to force the USCIS to issue the decision if there is a significant delay. So the mandamus litigation is a court case where you sue the Department of Homeland Security because they have not kept their promise.
Wow.
Yeah.
All right. Next question. Is it possible to apply for adjustment of status while on visitor visa? My son is a US citizen.
All right. So this person is, no worries. But as long as the son is above 21 years and above, I hope, given the, background that, a lot of Sri Lankans, like, their children tend to be biological children. But when it comes to the Hispanic community, they tend to be like both biological and stepchildren, right? Because if it's a stepson, then you got to get married to the stepson's parent before the age of 18 to create that, right? Stepchild, step-parent relationship. But when it comes to Sri Lankans, 99% of their children are biological, and that's how they immigrate. So yes, even if you're on visitor visa, even if you overstay your visitor visa, right? Even if you work, doesn't really matter. You can proceed with the adjustment of status application through your US citizen's son, as long as the son is 21 and above. But there are things that we have to, do to make your application a success, and to avoid any RFEs, right? Request for further evidence and things like that. But as far as the eligibility is concerned, yes. Even if you overstay, it would not affect your case. You are still eligible. Yeah.
Great.
So can I ask a follow-up on that?
Yeah, sure.
So my parents, so I'm the son, and my
Alright.
parents are here right now. So when they apply for adjustment of status, does their circumstance have to change to make them eligible for adjustment of status?
Not at all. Not at all. Are they on stay? But I know these are confidential, information. If you want, you can reach out to me separately. But just to answer your question, even if they fall out of status, meaning, tourist visas, right? Visitor visas, they only, they only grant it at the CBP, at the border, or at the airport for 6 months, right? So
Right.
after 6 months, unless you extend it for another 6 months, you're going to fall out of status, right? So even if your parents fall out of status, even if they overstay that 6 months, we can still apply for the adjustment of status. No problem.
Okay.
Yeah.
How to reach you?
So they don't need to change any status whatsoever. Nothing.
We will publish Chanaka's phone number and the email at the end,
Okay.
so that
Okay. Thank you.
Sabrina, you can reach out to him
Thank you.
afterwards. Absolutely. Moving on to the next question. How do these new rules affect the pending NIW 140 petitions?
A national interest waiver, I-140. Okay. There are no, when it comes to employment-based immigration and family-based immigration, there are no known changes in policy so far. That doesn't mean that they are not going to change. They may change in the future, but as of now, the status quo remains the same. The policy, the procedures remain the same. It's just the deportation enforcement that they have actually they have gone back to their old methods and forms of enforcement, right? They have actually changed from the Biden administration. They have changed the deportation procedure and how things are done in court. But as far as the employment immigration, family immigration are concerned, the status quo is the same. It's the same. But, only time will tell, right? We'll see in the future.
Thank you. And next one is I'm on a work visa.
What should my child carry to school in case of ICE activity? Again, I think So, if the child is on status, I don't see an issue, right? So the proof of status, right? Copies of their visas, right? But then again, do speak to the school officials and ask whether they have a plan in case of ICE. If in case, because ICE cannot come like we discussed before, just willy-nilly and then, just swing their arms without a valid warrant. They have to have a valid warrant. So you can speak to the school officials to ask whether they have a plan. They must have a plan. I personally know that schools in California, they have actually taken precautions, right? They have educated their children, the parents, and their staff members. But if the child has status, then I'm not worried. Just carry proof of status. That's all.
That's the advice, right? So this is
Yeah.
something that I have also heard from many of the people I know around in Vegas, that their parents are in status. Obviously, kids are in school, and what should they be carrying?
Yeah. Yes. Certainly.
Thanks, Chanaka. Final question here. I sponsored my siblings in 2006, and they were approved to come in 2020. However, one sibling didn't proceed with the application due to family reasons. Now they want to move forward.
So usually, once the application is at the consulate, this is U.S. Embassy Sri Lanka, right? Once the application is at the consulate, you must go for the interview within 1 year. If you don't go for the interview within 1 year, then they are going to terminate the application. So, they were approved to come in 2020. Now it's 2025, right? So most probably they have terminated the application. Status check, meaning you might have looked up the I-130 petition, right? I-130 petition is not the immigrant visa application. So there could be an anomaly, right? A difference of status when you check the USCIS and when you check the status at the US Embassy in Sri Lanka. Because the rule is, if once the application has been sent to the US Embassy in Sri Lanka, you go, and once they fix the interview, you got to go for that interview. And if you are if you're unable to go for the interview, you have to reschedule. And if you fail to reschedule within 1 year, they are going to terminate the petition. So I think we have to double check with the US Embassy in Sri Lanka.
Yeah, can I ask a follow-up question on that?
Yeah, sure.
The petition did not go to Sri Lanka because the payment was because they didn't want to proceed, so we didn't make the payment.
I see. All right.
But
And when you check on SIAC, it's still available, right?
It's still available, and it says, but all the documents we submitted, it says it's it's all expired. But
Yes,
also the payment we made at that time, we made some payment. It says there, so we have to repay that.
Yeah, that expires after about a year after, if you pay and you don't submit those documents, and if you don't submit the immigrant visa application. So if it is still active, so it has not gone to the US Embassy, it's still at the National Visa Center. And I'm surprised because once the visa is available, again, even at the National Visa Center, you got to apply. I have one case just like you in Bangladesh. Even after like more than 1 year, it has been pending, and they recently came to me. We quickly paid the fees again, right? And we uploaded the documents and submitted all the documentation. Right now, we are waiting for the third stage, meaning the interview stage. So if you are saying that the SIAC is still active, we have to now act fast. Okay.
All right. Thank you.
No worries. My pleasure.
All right, those are all the questions that
Okay.
came through Q&A and previously. We are 14 minutes over, but this is a very important session. Anyone with any other questions or follow-up questions? All right, if you
Yes.
do not, Chanaka, I will stop sharing. You may share your contact details.
Yes.
We'll be sharing the presentation anyway, while people are still on the webinar here. Do you want to share your screen and put up your contact details, or do you want me to send it to them?
You could share, Aruna,
Okay,
and
sounds
for your
good.
fellow members of the association, and then they can reach out to me. I'll be more than happy to provide my services. No worries.
Absolutely.
And I thank you, Aruna, for this opportunity so that I can educate the members. These are vulnerable times, especially for everyone. These are dangerous times for everyone. So, but thank you for coordinating this and arranging so that fellow Sri Lankans can, know their rights, right?
Absolutely. Thank you as well, taking the time. One thing is that taking the time to be a mentor in our mentorship board with Dr. Lakshman Denvitian and another bunch of elite members, and taking the time today to educate everyone. This video, as I mentioned before, is being recorded and will be shared across our social platforms for the wider community who are unable to join us today, for their benefit as well. And along with that, we'll make sure your contact details are published too, in case they want to get in touch with you for any follow-up action. Lakshman, do you or anyone else? I know that our committee members are joining too. Any other final remarks? Lakshman, you're on mute.
Can you hear me now?
Yes.
Yeah, I would like to thank Chanaka for spending an hour and a half of your precious time on a Sunday. You could have been on the golf course, but thank you for giving us all this information. I think it's a very informative, and I hope people learn something out of it. Thank you.
Thanks.
All right. Thank you, everyone. It is time to adjourn the session. And if you have any follow-ups, we discussed how to get in touch. Have a wonderful rest of the day.
Thank
See
you.
guys. Thank you. Thanks.
Thank you.